But that's what some of the people and tribunals have said about me over the years. Right, so onto the main topic. We're going to obviously discuss forensic delay analysis, and I want to break this down into 4 parts. I first want to just examine what we actually mean by forensic delay analysis, as opposed to just other types of delay analysis, perhaps. I also just want to briefly touch on the role of what a delay expert does. So that's my day job, and I'll just go into what's expected of a delay expert, what objectives they're trying to achieve, and why the delay expert is different to, say, a lawyer or a claims consultant or a barrister. We'll then move on to some theory, and unfortunately, we do need to learn some theory to have a proper understanding of the topic. But hopefully you'll enjoy the theory, because really, if you understand the theory, you can very, very quickly get to grips with a delay analysis that you've been issued, perhaps by a contractor, or indeed you can appraise the strengths and weaknesses of your own delay analysis just by understanding some key theories. And then we'll turn to methodologies, and I'll just introduce a couple of methodologies to you, which represent 2 schools of thinking in delay analysis, one being prospective, the other one being retrospective, and we'll examine why those methodologies produce different results. So that's the idea. On questions, feel free to type questions into the chat box. I'm not sure if I'll be able to see them immediately, but they'll be stored away for the end. But if I do see them come up, I'll try and answer them if that's possible. Okay, so let's ask this really basic question, because I think it's something that eludes people sometimes, and that is, what do we actually mean by forensic delay analysis? What we mean by forensic delay analysis is applying construction management knowledge to a legal dispute. So the forensic part of forensic delay analysis means that you're applying some kind of scientific or technical skill to a legal problem. That's what the term forensic means. And obviously, we're also doing delay analysis as part of that. So basically, we're trying to locate a delay in a program. We want to know when the delay occurred, the time it occurred, and also the physical location of the delay in the project. And once we've learned where the delay occurred in time and space, if you like, we can then start to investigate the causes of the delay, because we've narrowed down what the factual cause is going to be. The substructures were completed late, or the roof went on late. But now, having narrowed down the delay to a specific time and location, we can investigate what caused it. And then finally, what we're going to do is quantify the delay based on different causes, because very often you find that a delay is caused by a number of factors in succession or in parallel. And then the final challenge is just to quantify the delay as to specific causes. And of course, this is valuable because we want to be able to tell, say, a tribunal or a contracts administrator who's reviewing our claim what caused the delays to the project. And presumably, we're going to try and argue that one of those delays was one party's or the other's risk. So that's kind of what forensic delay analysis is, and the objectives that we're trying to achieve in general. Obviously, it's a bit more complicated than that sometimes, but that's it in a nutshell. Another really important thing to understand is that an expert delay analyst is not like a sort of claims consultant or an advocate. An expert delay analyst deals with facts. So the delay analyst isn't going to be poring over the contract and trying to make arguments about time bar or anything like that. That's for the lawyers and the barristers and the QSs and the contracts managers on the project. The delay analyst sits at the bottom of this pyramid and determines the facts against which the law and the contract can be analysed. And what's often overlooked is that you need both a factual argument and a legal argument to make an argument in a case. So the delay analyst deals with the facts. The delay analyst carries out a factual investigation. He or she provides the foundation for the arguments in the dispute. So it's really, really important to understand that. But very often people get so bogged down with the legal stuff. But actually, I argue that the factual points are much more important, because without that, there is no legal argument at all. So delay analysts right at the bottom of this pyramid, really at the foundation of any delay related dispute, establishing what exactly happened and why the project was delayed. So when we think about the sort of different roles a delay expert could do, we're going to be essentially assisting a tribunal or a decision maker of some kind in making a determination of the dispute, or the claim, as the case may be. And typically, we're going to be looking at things like the critical path delay, and that's going to help the tribunal or the claim reviewer decide whether there's an entitlement to EOT or relief from liquidated damages, or delay-related prolongation costs. We're going to be looking at situations where, say, a defective design or defective workmanship caused delay, and that might assist with a claim for damages for negligence or for breach of contract. Very often we're asked to look at delays up to a termination date, because it is quite common that contractors or subcontractors are terminated due to progress or delay. So our analyses help decision makers determine whether a contract was terminated validly or invalidly, and either way what the entitlements were up to termination. There might be situations where, say, an insurer wants to loss adjust a claim, and let's say a factory burnt down. The insurer might wish to say, well, had the factory not burnt down, what date would it have actually been completed, and how much would it have cost to complete the factory? Because of course the insurer only wants to pay for the insured part of that event. So we might help insurers with that in that respect as well. And there's also some crossover here with quantity surveyors, because we also look very, very closely at productivity issues. So typically the delay analyst will look at the man hours, how many man hours were spent in addition to what was reasonable for different causes of disruption. And the quantum experts will look at things like the hourly rates and the overall cost of disruption that applies to those man hours. So as you can see, although primarily we're just trying to locate delays in a program, which sounds a bit boring, the actual use of that information is crucial to a whole range of very, very common disputes. So we find as delay experts that we're extremely busy all the time, working on a wide variety of work internationally on a wide variety of types of claims. So it's actually really interesting. Just to illustrate, I suppose, what a delay expert does and the value that they can bring to a project, there's a couple of cases that we can refer to. This one's quite an interesting one from last year, called Cartwright Pond v Wild. This was a technology and construction court case that involved a dispute between a residential occupier and a contractor. And the court said, which is a truism, I think, claims for either delay or disruption are often difficult for a party to present and for contract administrators and tribunals to assess, given the factual complexity of a major construction project. So I'm sure we'll all agree with that. We've all been in the situation where we're trying to figure out what happened on this job and why the delay occurred. But what we can see in this case is a situation where the judge did not actually have a delay expert available to help him in this case make a decision. So he said this. He said, whilst this is actually very far from a major construction project, I faced significant difficulties here because there wasn't much documentary evidence. There was no contracts administrator, but crucially, neither party had undertaken a detailed retrospective analysis of the causes of delay, and there was no delay expert evidence. So because of that, all the judge could do was try their best in the circumstances. And the risk of this, of course, is that one party or the other receives rough justice, that they don't have a precise understanding of what actually happened on the project upon which to make a reasoned decision. So, if you're in the world of claims, the moral or the justice aspect of the construction industry might not be so important because your role is to advocate. But ultimately, you know, particularly in the courts, what we are trying to achieve is the truth, and we're trying to achieve justice and fairness. And you really can't achieve that goal as well unless you know or have a good understanding, like in this case, of what actually happened and what caused the delay. Sorry, my computer froze. Another case that I just wanted to show you was this case, Secretariat versus a company. The case dealt with a conflict of interest dispute, actually, but as it turned out, Sir Justice Coulson, who heard this case in the Court of Appeal, had to think about what delay experts do. And what Coulson said was this: delay experts are usually construction professionals with a quantity surveying background. That's a bit controversial. I think the planners might disagree, but he's probably right at this level. The line between time and money is notoriously blurred, and in construction arbitrations, it can disappear altogether. But what he then set out was a description of a delay analyst, which is, I think, quite accurate, because a bit like accountants, it's not always easy to discern what specialist expertise a delay expert brings to the dispute. But that's kind of missing the point, because delay experts have a very different function. And he basically said that delay experts investigate. They collate the myriad of information relating to delay and quantum during the preparation of a case. And as a key component of the support team for the arbitration, they focus on particular factual matters which are going to be important in considering the delay claims and the cross claims. So by the time they produce the reports themselves a long way down the line, the subject matter of those reports will reflect that detailed investigation. So Coulson's quite cynical about delay experts, as you can read in the last line there. So in the Van Ord versus Allsea case, he said a little unfairly that delay experts' reports are simply vehicles by which parties re-argue the facts, which is perhaps a bit unfair. But I think he struck the right tone there in distinguishing, say, a delay expert from, say, an engineering expert, where an engineering expert has a very narrow question, you know, what caused the bridge to fail? And that might involve some calculations and some academic papers. Where by contrast, the delay expert has a different role, because they have to investigate on the facts what actually happened. But the delay expert isn't going to be looking at academic papers and theoretical things in principle. The delay expert is going to be looking at what actually happened on this case, so it's case specific. So hopefully you can sort of kind of see why we're doing delay analysis and the value the role can bring, as long as it's done properly. I want to move on now, unfortunately, to some theory. It is really important to understand theory. As I said, if you're the recipient of a delay claim or a delay analysis, or you're making a delay analysis, it's really, really, really important that you can critically analyze that claim, both internally for your own strengths and weaknesses, but also externally because you might wish to respond to it. And something I see happen again and again is that parties are like sort of ships passing in the night, where the contractor makes a claim, the contractor administrator panics and tries to reject it and comes up with silly arguments. And then the parties get into a debate about very sterile background points, which actually don't matter when we look at what actually happened on the project. So to avoid all of this background noise and all of these letters that are meaningless and nobody looks at if the case goes to court, it is really important that you can very quickly understand, is this delay analysis accurate? And if it isn't, why is that? And obviously the objective, I would say, for both parties is to get an accurate account. So then you can start to think about, well, what other methods might be used to produce the accurate account of the delay? So when we talk about delay analysis theory, we can break it down very, very broadly into three key issues or questions. And I just want to go through these key issues and questions one by one, and we just want to reflect on them, just to understand what their implications are and how they can be used to analyze a methodology or a claim that you receive or are preparing. So the first question is, Prospective or retrospective? This is something you can probably all relate to. We have two possible approaches when we undertake a delay analysis. We can either take some kind of electronic program and make a change to it. We call that impacting. So we've all heard of an impacted program or a cause effect program, this sort of thing. All of that stuff, which is driven by software and modeling and changing logic links, the kind of things planners do, that's really falls into the category of prospective delay analysis. It's creating a hypothetical model of what could have happened somewhere far away in the parallel universe, but it doesn't actually show what happened. By contrast, of course, we can do a retrospective delay analysis. We don't have to impact any program when we do that. That's a waste of time because we should already know what happened because it has actually happened. So what we tend to have to do in this sort of analysis is investigate information. So we're going to be creating things like as-built programs, investigating when things happened or didn't happen on the project. We're going to be investigating chronologies that relate to our as-built program. We're going to be looking at the construction methodology very closely as well. So basically, retrospective delay analysis in principle shouldn't involve any sort of program manipulation or impacted programs because by definition you should actually know what happened, so all of that's unnecessary. So they're the two sort of philosophies, I suppose, and this is really overarching all of the theories that we're discussing today. So I'm going to quote a little bit from the Society of Construction Law Delay and Disruption Protocol. So if you don't know what that is, just stick it into Google and you'll find out. But it's basically a very, very good protocol of principles that relate to good claims and project management, program management. But it also, I would say, is probably the leading authority on different types of delay analysis and how they work in a very broad sense. So if you haven't seen the Society of Construction Law Delay and Disruption Protocol, but my recommendation is download it after the call. If you have, you'll know that there's a second edition out now. It's been out for a few years, but the 2017 edition is the one that's up to date. So the Society of Construction Law says this: a prospective delay analysis identifies the likely impact of historical progress on delay or delay events on a future completion date. But the issue to note is that the conclusions of a prospective delay analysis may not match the as-built program because the contractor's actual performance will differ. And the reason that it differs is because of things like resequencing or redeployment of resources, and the contractor might do that, for example, to avoid liability for liquidated damages. It might wish to mitigate the delay, or indeed there might be other events which are the employer's risk or the contractor's risk, which change how the project's constructed again. So in a prospective delay analysis, we don't care about all of that stuff at the bottom of that slide there. We don't really care if the contractor resequenced the work or didn't, because what we're producing is something that forecasts a possible situation that might happen in the future. So we have to be really careful with prospective delay analyses if we're looking in the forensic delay analysis context, because prospective delay analyses are a tool for a job. We are going to use a prospective delay analyses if we need to, and the situations where we might need to are for things like quotations. If we're asked to give a quotation for a variation, then clearly the variation probably hasn't yet been carried out. So it's useful then to produce a prospective delay analysis to show the impact of, say, changing the floor from timber to precast or something like that. We might wish to give an indication of the likely effects of a delay. We see this in, say, the JCT contracts, where we have to give a notice as soon as we can, giving an estimate of the likely effects. So to do that, if the event's one that's ongoing or that's going to occur in the future, we might want to do a prospective delay analysis for that sort of thing. And if you're on the project, and you've got you're doing a bunch of EOT claims and you're working with another planner or project controls manager, no problem, do a prospective delay analysis as long as you're doing it near the event. The challenge here is, though, that these prospective delay analyses are, as you can say, is what it says on the tin, they're theoretical. They're inherently theoretical forms of analysis. What tends to happen is that the contractors tend to like prospective delay analyses because they tend to show more delay, let's say, than was actually incurred if we look back. We'll come on to why the prospective approach does that a bit later, but the challenge is that if we do a prospective analysis initially and our claim isn't accepted by the contracts administrator, then ultimately, if we end up in adjudication or court or arbitration, we have to do a retrospective delay analysis anyway. So prospective delay analysis is great as long as you're using it for what it's meant to be used for, which is prospective delay analysis, but not really suitable in forensic delay analysis because it's just theoretical. It doesn't show what actually happened. The opposite philosophy then is retrospective delay analysis, and this is really simple. We're trying to identify the actual impact of a delay event on the actual as-built critical path of the project. Actual or as-built critical path of the project. So much simpler here. We shouldn't, as I said, have to worry too much about modeling anything, because we should now be able to refer back to site photos and other as-built records to determine exactly what happened. So we're not going to do a retrospective delay analysis for a variation proposal, plainly, because the variation hasn't yet been carried out yet. But what we tend to use retrospective delay analyses for are for finding out what actually caused delay. So you might have to do a determination if you're a contracts administrator, and very often by the time you do that, the events have passed. By the time you receive the contractor's claim, the events are many months before, so it makes no sense then to try and do a prospective delay analysis. If you're a contractor, you might have issued a series of prospective delay analysis notices along a project, but at some point you want to look back and just make sure that you've properly accounted for all the delays, because you may not have actually identified all of the relevant events if you've just been doing prospective delay analysis. You haven't actually investigated what did really cause the delay. So sometimes as a contractor, you want to look back and perhaps just make sure you've found out all of the real causes of delay, so you can make sure that they're claimed, say, in a consolidated EOT submission. So typically we would do that under, say, a JCT contract at a final account stage. And obviously, if you're in court or if you're in adjudication, we wouldn't normally want to do a prospective delay analysis, say in limited circumstances. Perhaps we're under an NEC contract and there's a CE that's disputed or something like that, a compensation event. But generally speaking, tribunals, as we'll see a bit later, tend to prefer retrospective delay analyses. So because retrospective delay analysis is based on facts and actual events, this is usually much more suitable to forensic delay analysis, the sort of delay analysis we use in legal disputes. The key question overarching all of this is where does the critical path run to a milestone or a section of work? And one of the theoretical issues that we have to understand is that there are different critical paths. So this is a quote from a case called Motherwell v. McCaffell. The question the court said was, key is the delay on the critical path? And once we have a delay analysis, the results must be tested to accord with common sense and fairness. So does this delay analysis make sense? So what we see again and again is the courts recognizing that the critical path is important. And the reason it's important is because the critical path is the link between cause and effect. We often hear people saying, well, you have to link cause and effect, without really thinking about what that means. But if you've ever wondered what the link between cause and effect is in a delay claim, then just refer to the critical path, because it's that path that links the cause to the effect. So it's crucially important as a matter of causation that we do a critical path analysis, that we don't just merely look at individual events in isolation of other events, that we actually look at the entire project and the progress of the work and place the events in the context of that, so we can form a judgment about whether in fact something was on the critical path. But as I said, the problem is there's actually 3 different types of critical path that we might want to use, and this is something that some people sometimes overlook. So it's useful just to quickly understand what these critical paths are, and why they might be useful or not useful, depending on the case. So the first type of critical path is the planned critical path. It's quite obviously the critical path planned at the beginning of a period or the entire project. So pretty straightforward. This is a planned critical path. What you can see on the screen is a very simple project for the erection of a structure into which we're going to connect a pipeline. And what we can see on the plan here, indicated in red, is that the structure itself is on the critical path, because we can see at the bottom of the screen the pipeline connection has about 2 weeks of float. So the planned critical path, quite logically, is that the structure will be critical and the pipe connection will be made well ahead of the structure. So that's the planned critical path. Slightly more complicated concept is what's known as the actual critical path. And we have to think about this a little bit more. When we talk about the actual critical path, this is a formal term which describes the contemporaneous critical path at a point in time, say in a window or a period of time during the project. And what we're trying to do here is we're going to slice the project into periods. This is why we hear about delay analysis using windows analysis mainly. And in each window, we're going to determine what the critical path was at that time. We don't just do this to make the report very long. We do this because we accept that critical paths change over time. So if you're building a house, your critical path might be running through the roof. But if the house falls down, then the critical path changes. It runs through the demolition and the rebuilding of the house. So it's pretty obvious that critical paths can change, and this this approach takes into consideration that does happen, that critical paths change over time. So going back to our project then, we can have a look at the program in week 5, and we can see that this point in time, we have a change in our critical path. So from weeks 1 to 5, our structure has been going somewhat as planned. The critical path ran through the substructure and then the steel frame. But sometime between week 1 and 5, that 2 weeks of float that we had on our pipeline has been eroded. So something happened before week 5 to cause at least 2 weeks of delay to the pipeline. And as a result of that, the pipeline is now the critical path. It's the longest path to completion. It's driving handover. So on this very moment in time, in week 5, this is the date the critical path changed. So if our analysis looks like this, it means that we're identifying the actual critical path, because in window 1, in weeks 1 to 5, we say the substructure was critical. So we might be interested in substructure variations or disruption to the steel frame. And then after week 5, we say that the pipeline was critical. So we might be interested in variations to the pipeline or other things that affected the pipeline and thus caused critical delay. We then have a third type of critical path, just to add to the confusion here, and this is called the as-built critical path. And the idea here is that we take our program and we draw a line through the as-built program. And what we're trying to do here is find out the retrospective longest path in the as-built program. But crucially, in the as-built critical path approach, we don't really identify critical path changes, because we're taking the final program. We're not actually tracking the project as it was built, but instead we're just taking the final program and drawing a line backwards through it that represents the longest path. So what we can see here is the same project, and now looking retrospectively backwards at week 11, the pipeline finished last, so therefore our as-built critical path ran through all the work connected to the pipeline. So you'll forgive anyone from thinking at the end of this job that the pipeline connection was always the main problem. But you'd also forgive the construction manager standing there in week 4, because he knew or she knew exactly how the project was built, saying, well, the pipeline connection clearly wasn't critical. We had loads of float in the pipeline in the start of the job. So you can see how just looking at the project from different perspectives gives you different critical paths from the beginning of the project forwards, during the project, and also backwards. We can see on a very simple example, we've ended up with 3 different critical paths or combinations of critical paths. So which one of these is the best? Well, generally speaking, the planned critical path is a bit theoretical, so we tend not to use that. And interestingly, the as-built critical path is somewhat theoretical as well, because as we can see in this ERDC versus Brunel University case, the as-built critical path does not recognise the fact that the critical path evolves during the project. So on a simple project, the as-built critical path here may well resemble the actual critical path. It might be exactly the same, and that happens more commonly than not. But on a few projects, more extreme examples, the actual critical path will differ from the as-built critical path. And parties, both contractors and clients, use this opportunistically because they want to select a critical path that most suits their version of reality. Because if all this contractor delay was in the pipeline, then the client might say, well, there's no EOTs on this job because of you were delayed in the pipeline, weren't you? But equally, if we go to the actual critical path, the contractor might have been genuinely delayed for 2 or 3 weeks in the substructure, and would legitimately be able to argue that the substructure was a cause of delay. So one of the questions to ask yourself is, what exactly is this critical path? Is it an actual critical path? Is it a prospective planned critical path? Or is it an as-built critical path? Because you really need to understand that. But crucially, both the planned critical path and the as-built critical path may not correspond with the project records because the project records are produced during the project and describe how the project was actually built. And neither the planned or the as-built critical path really properly reflect the sequences of work and the mitigations and the resequencing that happen progressively. The final issue in theory, is how we determine causation. What I mean by causation is linking a cause to an effect. So what's a cause? Well, it's very simple. It's the reason why something happened. What's an effect? Well, very simply, it's what happened. And also, we can then join those things together. A cause and effect analysis is just simply explaining why something happened. There's nothing really complicated about this at all. So again, we often hear people talk about cause and effect analyses, that there isn't any sort of discrete thing that you're doing there. You're just explaining why something happened. That's what a cause effect analysis is. So interestingly then, we can do a cause and effect analysis in 2 ways. The first way is to find out all the different causes that possibly existed on a project, causes of delay. And we typically refer to, say, our letter register to look at all of the delay notices to do this. And then for each and every one of those notices, we're then going to try and determine an effect. So this is typically what I think most people would intuitively understand a cause and effect analysis to be. We start with a list of potential causes, and then we try to measure their specific effects. So the SCL delay and disruption protocol says where there's a discrete employer risk event and an EOT application is being made at the time, then the cause and effect approaches are generally the right thing to do, because you don't want to just wait and see. You want to be able to say, well, for delay notice 1, I want you to give me 10 days of EOT or whatever it is. So starting with the cause and then trying to analyze the effects for that specific cause is one way to do it. Now, the issue here is that we tend to have to do this by modeling. So cause and effect analysis in this order we usually have to use program software to impact or collapse programs, because it isn't usually the case that you can just say that one event in isolation caused the delay. You have to think about what actually happened in respect of all of the project, all of the progress. So while intuitively we can try to calculate what the effect of one specific event is, the only real way we can do that is by using some kind of modeling approach, because in reality there could be tens of events all ongoing at the same time. So it's a bit of a fallacy to just look at one event in isolation and then try to argue that that caused delay. But we can do that by modeling. We can assume that all of the other work went to plan apart from this one event, and then we impact that onto the program, or indeed we might collapse the program. The problem is that's usually quite theoretical, because you're not actually considering all of the events that happened on the project together at the same time. You're only considering the one. So cause and effect approach is one way of doing it, and this is a good way, again, right near the time you're doing the analysis. The opposite approach is to look at effect and cause, and this is actually the opposite way round. So instead of looking at an individual event, what you do is you start with the effect. You say, well, look, let's not get too bogged down into specific delay events just yet. Let's start with identifying where the critical path of the project actually ran. And if we can find out that as a matter of fact, then we are in a very efficient way covering all sorts of delay events that might have happened. And once we find out where the critical path ran, we can locate the events that actually fell on that critical path. And as such, we can determine what really did cause the delay. We don't have to do any modeling or anything like that. So what we do in the effect and cause approach, we flip it round. We find the cause after we found the effect. So we ask ourselves factual questions like, why did the substructure incur 2 weeks of delay in June? Or why was Zone A completed 4 weeks more quickly than planned? If we're asking ourselves factual questions like that, it means we're doing an effect cause analysis. We're not saying how much delay did delay event one cause, because that's a cause and effect question. We're trying to find out why actually something did happen, and if that's delay event one, or if it isn't, it doesn't matter. We've found out what actually did cause delay. So what the SEL protocol says on this is that effect and cause approaches are generally more forensically reliable. That is, they're more reliable for dispute resolution because they consider any and all potential causes of delay. You're not introducing a bias by just picking out one cause of delay and then trying to find a delay that might not have really happened, but you can create an impression that it happened just by isolating one delay and ignoring all the others. So hopefully you can see now how the theory works. What I want to do now is just turn on to how that theory translates into different delay analysis methodologies. Methodology is really important because an expert in delay analysis has to state the methodology that they've used in order that a court can test the conclusions reached by the delay expert. It's really, really important. So all a methodology is just a combination of the theories that we've just discussed translated into a series of steps. So if you understand the theories that we've just discussed, you can pretty much understand all the methodologies. There's a few key principles that also practically speaking underpin methodologies, and I've listed 5 of them there. I think the main one really is that, at least in forensic delay analysis, what we're trying to do is derive our findings from factual evidence of actual delay. There's lots and lots of case law that supports factual methodologies over theoretical ones. You can see how in that second key principle there, that theoretical or complex computer software analyses are usually undesirable. And there's a whole stream of case law that confirms this. We also know from the courts that a methodology should usually be focused on the critical path. So a methodology that doesn't do that is unlikely to be persuasive to a court. And the other two key principles are that an analysis shouldn't be subjective, and also what you shouldn't be doing in a delay analysis is trying to reject or inflate a claim. You're not doing forensic delay analysis. If you are doing that, you're doing advocacy. So you're missing the point a bit. So with those principles in mind, we've got the theory, we've got a few practical principles. What we'll see is really the methodologies are just combining different theoretical differences in the three areas we've already discussed. So again, this is a table from the SCL protocol. What you'll see on the top is the different types of analysis categories. So, for example, we spoke about the difference between cause and effect and cause, and you can see that listed there. We can see that there's different ways of identifying the critical path. You should be familiar with that now: as built, retrospective, contemporaneous actual, or prospective planned critical path. We can see there's different ways of measuring the delay and determining causation, whether you look at things retrospectively or prospectively again. And finally, we can see on the left-hand side of the table that the approach we take is going to be either a software modeling approach or a factual investigation approach. So hopefully now you've got some understanding of the theory, you can quickly understand why these different methodologies might, say, produce different results. So I've circled two methodologies there, and I just want to quickly take us through those so we can properly understand why, say, a cause and effect approach, which uses prospective delay impacting, gives a different answer to, say, a retrospective approach like the one of the Windows analysis. So we'll look at the time impact analysis and we'll compare that to the Windows analysis, and we'll have a think about why the results might be different. So here's a really simple example of a time impact analysis. We've got a project with 3 zones. What we're going to do in a time impact analysis is just before the event happened, we're going to update the program in the software. And then we can see that before the event happened, there was some kind of pre-existing delay. We can measure that delay by looking at the forecast end date, and we think it was about 3 weeks. We can then take this updated program and impact onto it, in this case, a design change, which led to some late drawings. And now we've impacted that event onto the program, we can see the program pokes out even more. We can measure that further effect, which in this case is 5 weeks. Now, the challenge here is that we're relying on several assumptions. The first is that we think there's no progress that was possible until we received these drawings. The second is that zone B here must also delay zone C because that's what the program says. There's a logic link in the program. So without doing zone B according to the program, we can't possibly start zone C. And if all those assumptions are correct, then these drawings probably did cause 5 weeks of delay. The problem is here, this is totally theoretical because we don't actually know if this is what happened, because we don't care, because this is a prospective form of delay analysis. It's not real. It doesn't represent what happened. So as you can see, time impact analysis is just a case of updating a program, impacting it, recording the movements in the forecast end date. But crucially, we have got lots of assumptions here about how the project might have to be built. We haven't yet tested what actually happened. The other approach is to do what's called an as planned versus as built Windows analysis. I just need to set this out a bit more because it's not so intuitive, I suppose, if you're not familiar with this stuff. Here we're undertaking what's called an effect cause analysis. So the idea is the first step is to actually determine where the critical path ran. And we have to do that first because we need to focus in on that critical path to locate the delays. And once we've done that, we can then measure the delays, and we do that over a series of windows. So this is a classic effect and cause analysis, which applies a retrospective philosophy and focuses on the actual contemporaneous critical path. So same project, same information, except here we don't have to worry about any program modeling or anything like that because the project's finished. And we can see immediately that the project finished 2 weeks late. So the 5 weeks of delay caused by the drawings was perhaps a bit exaggerated. So how can we analyze this project without impacting the programs? Well, it's actually quite easy. Once we've got a clear idea where the critical path ran, you have to do that through investigation, looking at the programs that were produced at the time, using construction methodology and some common sense. Once you figure out where the critical path ran, you can then think about where you think a delay event might have occurred, what the important parts of the project are. And based on this information, you can then start to measure the delays between the planned and the as-built programs over a series of windows which frame important events. So there might have been a major variation, or the critical path might have shifted from the substructures to the superstructures. Whatever it is, you can use windows to measure the delay at key points in time. So that's what we do. We just compare this is what it says on the tin. We compare the planned and the as-built programs. But crucially here, we focus on the critical path to make those comparisons. We have to do that. So what we can do is in the first window, we can measure the delay between the planned and the actual completion of Zone A. And we can see the project was in 3 weeks of delay before the event occurred. So that corresponds with our time impact analysis, actually. We can also then measure the delay after the drawings are issued. And interestingly, what we can see is that the project's now only in 2 weeks of delay. Because irrespective of the fact that Zone B didn't start because of the drawings, the contractor went ahead and started Zone C anyway, and actually started it in a similar amount of delay than it finished Zone A. So what we can see is the delay at the end of the project was also 2 weeks. So really, this drawing change hasn't actually caused any further prolongation to the project. But what it has done is possibly or probably introduced quite significant costs in having to resequence the work. So a contractor trying to make a delay claim, an EOT on a time impact analysis, might have made the wrong claim here. They should actually be trying to make a mitigation claim, because they have done a good job and mitigated the delay in this scenario. So at the end of the project's still in 2 weeks of delay. So we don't have to use any software modeling for this. It's really straightforward. But we know that the project was actually in 3 weeks of delay before the event started. And interestingly, the project was in 2 weeks of delay after the event ended. So actually, the contractor managed to achieve a 1 week mitigation by resequencing the work. So not a prolongation claim here, but certainly a mitigation claim. So almost there. What we can see when we compare these two methodologies and others is that typically one of these prospective cause and effect approaches is going to generate much more delay in typically. And the reason for that is because it relies on, in some cases, several hundreds of assumptions if you're thinking about logic links in a program. And also, it kind of ignores what happened during the event. It doesn't think about whether the contractor actually resequenced the work, or it maybe incurred more delay in other areas of the project to make the critical path change. It only assumes that the employer's delays usually were the ones that had an effect. By contrast, the retrospective analyses, the effect and cause approaches, the ones that look at the actual critical path and don't tend to be computer reliant, tend to show arguably a more accurate account of delay. And in this case, we can see that probably the prospective approach is not suitable. It shows delay where none in fact existed due to the contractor's valid mitigation efforts. So I've just listed what the results would be using the other methodologies there. I won't go into those just now, but what you can see on the left-hand side of the table is that generally the computer-reliant methods tend to produce very large delays, and generally the factual retrospective methods tend to be arguably more accurate. And in this scenario, there wasn't any delay due to the mitigation that was achieved. So I did a paper last year. You can have a look at that. It's called "How Effective is Adjudication for Resolving Delay-Related Disputes?" And what I did in that, as part of that research, I surveyed, did a case study on 10 projects that went to formal dispute, and I had a look at what the adjudicator's preference was in terms of delay analysis methodology, and I found that in the majority of cases, the adjudicator tended to prefer a retrospective delay analysis. So you can see in black the adjudicator's preference, and that very much corresponded with the expert's preference on methodology. And generally speaking, as you can see very clearly, the Windows analysis, the second methodology that we've just reviewed, was the most popular. So if we ask what's most persuasive, most delay experts know, and you'll probably have an intuitive understanding of this, that a factual reality-based analysis is preferable. Okay, so that's the main content. I just want to quickly introduce you to the course that I run or help run. We offer a BTEC level 7, which is a master's level award in forensic delay analysis. And this award is accredited by Pearson, who you may have heard of. It's the UK's largest awarding body. So it's not a CPD type qualification, if that's such a thing. This is a formal accredited qualification. What we teach and what you've just seen is a very small extract from the course. So we want you to learn how to formulate robust methodologies for forensic delay analysis. We learn you how to evaluate the reasons for delay based on fact-based analysis primarily. And the whole perspective of the course is that from an expert witness. So we teach you how to write robust expert witness reports to present your delay analysis. So this isn't a sort of project controls course or trying to teach you how to do Primavera P6 logic links. The most cases in forensic delay analysis by delay experts, we use very little programming software actually. Most of our time is spent looking at records and as-built positions and so on. So the focus on this course is a bit different from other courses. It isn't a course designed by planners for planners. This is a course designed by practicing delay experts for those that aspire to be a practicing delay expert. So that's the course. I'll give you some contact details in a moment, but you can check out the website, the link's down there. Okay, I've run over slightly in my main bit, but I hope some of that was useful. We've got some time for questions now, I suppose. Now, I haven't been monitoring the chat, primarily because I couldn't see it very well. But Suzanne, could you help me with the questions? Did any come up?
Yes, there's nothing in there at the moment. So if anybody has any burning questions they'd like to ask Alan, please do type away quickly. Thank you, Alan. That was a very interesting presentation. You covered a lot of material there. Thank you.
No, it's a pleasure. Yeah, it's a very tricky topic, but I think sometimes overcomplicated, really.
Nope, there's nothing coming in. Obviously covered it so well, Alan. Here we go. Okay, thank you. There's two just popped up. How do you deal with effect and cause when there are a large number of causes, i.e. resequence, but the effect of all aren't clear?
That's a good question, Stuart. I suppose you're thinking about an effect and cause analysis in a sort of cause and effect way. So let me just explain that. The idea of doing an effect and cause approach is for dealing with multiple causes of delay. So what we're trying to do in effect and cause approach is not bother ourselves immediately about lots of possible causes of delay, but instead we're going to go straight to where the effect was felt, that being the critical path. And by doing that, we narrow down all of those possibilities to only a very limited handful of possible events, i.e. those that actually fell on the critical path. So as long as we identify the critical path first, then we remove tens or hundreds of possibilities of what might have caused the delay or could have caused the delay, and then we're left with a very short list of things that probably did contribute or cause the delay. what happens then is your analysis becomes infinitely easier, because then you can weigh up, say, two events together, and if you look at them chronologically, you can usually find out where the effects were felt. So if, say, the foundation was delayed by a week, you can probably link that to a discrete cause. If then the brickwork was delayed by another week, that's probably linked to another discrete cause. So the crucial thing there is, if you try and do a cause and effect approach by looking at all the 100 possibilities, you're going to be there for a very long time, and you're going to get yourself very confused. So that's precisely why we do an effect and cause analysis.
Thanks very much.
Thank you. Thank you. Got another question. How does delay analysis differ between NEC and JCT contracts?
That's a very good question. I think that the NEC contract is much more prescriptive than JCT, and NEC obviously requires the project manager to assess a delay, arguably prospectively. So what the project manager should do is deal with the EOT event as close as possible to the date, the dividing date, effectively, the notification date, or the instruction date. So for that reason, because NEC basically requires the project manager to be assertive and proactive, it is necessary and it is correct to do a prospective delay analysis, because if that's not done, then of course we end up in a typical JCT scenario where we're having to look at things retrospectively at the end of the project. So NEC does, if you want to think about what the best methodology for an NEC is, then probably time impact analysis is the best approach on a project. If you're looking at it retrospectively in an adjudication, then usually you need to probably figure out also what actually happened. But crucially, you're focusing on the effect at the time of the event. You're not also then considering future mitigation in an NEC, unless it's something that a reasonable contractor would have done. JCT is very different, because although a JCT in theory can be worked like an NEC, it very rarely is, because the project or contracts administrator is not mandated to do so. And the JCT actually requires the contracts administrator at the end of the project to itself perform a retrospective delay analysis, even for events that haven't been notified by the contractor. So JCT tends to be, frankly, where many of the disputes occur, and also most suited to a retrospective delay analysis. So the difference really is in the philosophy of the contracts administration. Obviously, if you're in an NEC contract that's been operated like a JCT, and it's been 2 years since the event occurred, then it's probably not a good choice to then try and theoretically recreate things that should have been done at the time, because those things weren't done. So yeah, interesting question.
And I'm going to skip down to this one next, because I think it sort of follows on. As an adjudicator and arbitrator, how should the parties submit delay analyses when under NEC contracts the analysis should be prospective even after the event?
My approach is that if the analysis is if the dispute is around the assessment of a discrete compensation event, so let's say CE23 for changing the brickwork spec, or for a discrete event, then I think an adjudicator and the parties should approach that in the way the project manager would, by looking at a prospective delay analysis at the time to measure the effect of that change at the time. However, some disputes under NEC are not like that. They involve multiple events that very often haven't been subject to any kind of assessment at the time. So the dispute's not usually about a specific assessment. It's usually a more broad, overarching dispute. So I think to the extent the parties haven't operated the contract properly, and thus haven't really fixed a clear difference at the time, the more that happens, the more likely it is, in my view, that a more retrospective analysis is appropriate. There is some case law precedent for that. There's a case in Northern Ireland, as you probably know, called Healthy Buildings versus Northern Ireland Executive. And we know that by the time a case goes to a tribunal, the tribunal is entitled to look at what happened. They don't have to shut their eyes and grope around in the dark. So although the NEC is directive to, say, a project manager and a contractor about what they should do, and in the spirit of the contract, I think that the analyst should follow that for discrete issues. Unfortunately, many NEC disputes that actually go that far tend to be highly complicated and for things that haven't been notified properly or even analysed at the time. And in those situations, as we can see from the Northern Ireland case, it isn't appropriate for a tribunal to just look at things theoretically. So a long answer, but I think it really depends on the nature of the event. If it's a single discrete issue, yep, prospective analysis, that's exactly what the NEC requires you to do. If it's a big kitchen sink final account where the parties are in dispute about everything and haven't really done a proper contracts administration, then I'm afraid, you know, the most efficient solution is to look back at what happened.
Just got one more, Alan, please, if you don't mind. Which software is best for doing the Windows analysis?
It doesn't. Software is totally irrelevant. They all do pretty much the same thing. You know, there's a little bit of difference in how the software operates, but they all basically do the same thing. So the form of software that you use is a bit irrelevant. You know, Primavera P6, Asta Power Project, they all do the same thing ultimately. They model critical paths and things like that. So I don't personally have a preference, to be honest. I mean, I suppose if there's a choice between, say, Microsoft Project, which is a bit of a more user-friendly amateur package, to say Primavera P6, I'd probably want to use Primavera P6. But you know, the software itself, they all ultimately do the same thing. So as long as you know how to use your software, there shouldn't be any fundamental differences between the different softwares.
Thank you, that's fantastic. There is one more question in here, Alan, and it's just asking whether the participants can have a copy of your slides.
Of course, yeah, you're very welcome. So I'll issue those to Susan, and then hopefully she can distribute those.
Yeah, okay, that's fine. So if you would like a copy, if you could either just quickly pop a message in the chat room or email me, we'll get those out to you. So first of all, and most importantly, sorry, my cat. Thank you, Alan, for a wonderful presentation. Thank you to everyone else for attending. We hope you're going to be able to join us again for one of our first Thursday events. Our next one is the 3rd of November. I think it's the 3rd, let me check, yes, where Simon Kendall will be back with us again, and he's going to be talking about procurement this time. And in December, that's December the 1st actually, Andy Hewitt will be doing an introduction to FIDIC contracts for us. So we will be sending around information about those in due course. So thank you very much. Dr. Hampton, would you like to add anything before we go?
Just to say that was really good, Alan. Thank you very much indeed. Very informative. It's very good to hear someone who has to provide expert guidance as well, because obviously you have to be fully aware of your subject matter and be confident enough to articulate that in various forums. That was very informative in lots of ways. So really appreciate you taking the time to come there. Hopefully we'll, if you're not already, we'll be sort of seeking your membership of QSI. Please do sort of come back at some stage as well, just to maybe share a case study next year. I'm sure you're going to find one very sort of informative that we'll sort of appreciate next year. But no, huge thank you from myself and all QSI members. That was really good. Thank you, much appreciated. Thank you, Suzanne.
Okay, thank you very much, everyone. We'll be in touch, and just drop me an email if you need anything. Okay, thank you.
Thanks,
bye-bye.
everyone. Bye bye.
Bye, everyone.
Bye bye.
Cheers.
Bye bye.
Hi, everybody. Bye, Suzanne.
Goodbye. Is that you, Keith?
It is me, yes. Sorry, my apologies for being late, but
It's okay.
they put some temporary car park, some temporary traffic lights on my route. I drove up the road home last night, and then there were no temporary lights, and this morning there were temporary lights. It was blooming chaos still. Anyway,
oh goodness.
so I was delayed, but thanks very much, and thanks for sharing it as well.
That's a pleasure. So we're
But I'll see
catching
you
up with-
tomorrow morning.
Yes, no problem. We'll have a catch up then. I'll let you get
Yeah,
on
okay.
for today.
Okay. Yeah, I've got next
Okay.
one to go to now, next Zoom meeting.
Oh,
Take
blimey.
care.
Right. Okay.
See you
See
tomorrow.
you,
Bye.
Keith. Bye-bye.
Bye bye.
Bye.